Okay, let's get started. Welcome, everyone. Nice to see you today. Thanks for joining us. I guess I will introduce the webinar, introduce us, and we can get started. I am Melissa Steinman, and this is Sweepstakes and Contests, a global legal perspective, presented today by the Global Advertising Lawyers Alliance, in case you came to the wrong place. I know that happens often lately, at least to me. I am, as I said, Melissa Landau Steinman. I'm a partner at the Venable Law Firm. I'm based in Washington, D.C. We're a national law firm in the USA. My speakers today will be Carol Bertrand at Bertrand Legal. She's in the Dutch Caribbean. Brinsley Dresden at Lewis Silkin LLP in the United Kingdom. Daniel Haya at Hugenrad and Haak at the Netherlands. Sorry, there was a little pronunciation practice there. How'd I do? And Jose Antonio Orochi at Orochi and Lindner in Mexico. For our agenda today, we're going to generally discuss how we approach a global prize promotion first, and then get into our country by country discussion. We're going to try to cover not only the basic framework, the laws and regulations and rules for sweepstakes and contests, as well as maybe a little more discussion about things like what is consideration or specialized rules for each country. But then also some of the more specialized topics like influencers, rules for charitable sweepstakes, if that's an issue in the individual country. That's something we just added to the newly published updated edition of Gala's book about sweepstakes and contests. There were a couple of new topics there, so we thought we'd cover that. Also NFTs and crypto and how they can be incorporated into sweepstakes, how the rules may affect sweepstakes and contests. New developments, of course, in 2021 and 2022, and then some tips country by country for running a global campaign. So let's get on with it. So talking generally about how to approach a global campaign, this is something that, of course, I imagine that's why you're here. More and more, we're seeing global campaigns. Our marketing people come to us, our clients come to us and say, we want to do it worldwide. The laws vary very significantly from country to country. And of course, there are many, many countries. So sometimes it's necessary to try to put a finer point on that. You can't just put a set of sweepstakes laws up on the internet and say this is a good set. It should be able to apply for everybody. Indeed, you have to be aware of the fact that when you put a set of sweepstakes and contest rules up on the internet without any kind of country restriction, that's what you may be doing. So first and foremost, in the ideal situation, you call up somebody, you look at the Gala webpage, you call up somebody like one of us and you say, here's the countries we're thinking about, here's the countries that matter to us. Maybe we have offices there, maybe we have a lot of, customers there. Can you help us find counsel in each of those countries? That's sort of best practices. Keep in mind that regulators generally don't pay attention to a choice of law or a choice of forum clause in a set of sweepstakes rules. It's different from your typical contract that way. You can't just say UK law applies and that'll be that. So instead you need to focus on, where you want to target. You can both consider limiting the sweepstakes rules, say void outside of XYZ country, but also use geofencing, say, to limit who can see those rules. Use express acceptance of the terms and entry forms, again, to collect information about who's entering and get acceptance of the terms and conditions with upfront affirmation that your entrants are in eligible countries. Things like that can help you narrow down who's entering and make sure that you are complying with the laws of the countries where you are seeking entrance. Next slide. Am I now moving forward? Next slide. In terms of the kinds of variations we're talking about, obviously our panelists are going to talk about laws in their countries, but just a sampling of some other countries. You know, there can be the issue of whether sweepstakes are legal in a given country at all. I think many people by now are familiar with the fact that Canada does not allow games of chance. You know, there's that workaround where you have entrants in Canada answer a simple mathematical question. And if you look closely at sweepstakes rules where Canadian residents are allowed to enter, if you're not familiar with that, you'll see this built in where winners are supposed to answer a math question, but other countries have similar limitations on sweepstakes. There may be registration and bonding requirements, most commonly for sweepstakes. But Brazil does not limit just to sweepstakes. There are registration or authorization requirements in some cases up front for contests in Brazil as well. Australia is another country that requires registration. Jose will talk a little bit about their requirements. So you need to be aware of that sort of thing. Many countries have translation requirements for their rules. Also, some sorts of conduct may or may not be permitted, whether it's limitations on what you can request for intellectual property in UGC contests, what kinds of prizes you may give away. Can you give away a cash prize in every country? Tax requirements, or even just if you are going to try to ship a prize to residents of specific countries, do you need to worry about whether there may be customs issues or duties that have to be paid if you're trying to ship cross-border, and how are you going to arrange for that? So whenever you run this kind of global sweepstakes or contest, you need to be thinking through what the implications are that may be different if you just run a contest or a sweepstakes that's offered only in your country. Additionally, there are a couple of countries that have very complicated rules about when you have to have a drawing that's held in their country that can put you in a fix. If you want to hold the drawing in your country, and in fact, may have a requirement like in Italy that a public official has to be present. So you really need to be thoughtful about that ahead of time. In a couple of cases, it may even end up mandating that you have a specific drawing or sweepstakes for only residents of that country. And of course, there's privacy. So the privacy rules right now, are tricky, and you need to be thoughtful about that. Next slide. And Brinsley.
Thank you very much, Melissa. And hello, everybody. So the good news, just picking up on some of what Melissa was just saying, the good news in the United Kingdom is that it's relatively friendly towards sweepstakes and promotions in the UK. We got the cap code, which is administered by the Advertising Standards Authority, and they are a very active regulator. So your biggest risk if your promotion goes wrong is that it will be investigated by the ASA, resulting in a published adjudication. They can't impose fines, but they can impose, or they will publish their adjudications, and there's often negative PR that results from that. We also have, as I'm sure in other countries, we have a very active community of, we call them compers, these kind of amateur people who make a hobby out of entering promotions and competitions. They have dedicated websites and blogs, and they will post and say, "Oh, have you seen this? I think this is unfair." And then they'll all pile in and try and enter, and they'll all say, "Oh, yes, it doesn't work." And then they might all complain to the Advertising Standards Authority. So that's your biggest risk. The other thing I would then highlight here, the Gambling Act makes it pretty easy to run a promotion in the UK, even a promotion, a lottery, as opposed to a competition. So a lottery where success depends on luck, as opposed to a competition where success depends on skill or judgment. In the UK, you can actually run a lottery which is linked to payment. Well, I say the UK, I've got to be careful. In Great Britain, so in England, Scotland, and Wales, you can do that. But one of the wrinkles we have here is that the Gambling Act does not apply in Northern Ireland. So if you want to have a UK-wide promotion, you need to decide what your risk appetite is. Either you're just going to think, well, if it's UK-wide, is anybody in Northern Ireland going to take any action about it? Probably not, but it's not technically correct. Or do you want to have a no purchase necessary route or an alternative method of entry route where people can enter your lottery or sweepstake without having to make the purchase? And if you're going to do that, you probably want to make it UK wide. It would be a bit odd just to give that to people in Northern Ireland. Data Protection Act, probably the biggest single problem, making sure your privacy policy is compatible with GDPR as implemented into the UK under the Data Protection Act. And then the one that I think people forget is just the kind of the basic platform of consumer protection law, which is the Consumer Protection from Unfair Trading Regulations. Sometimes people call it CPUT. I prefer to call it the CPRs. And something that came up relatively recently was a £150,000 fine for a misleading promotion. Now, this happened in January 2020, and I only just found out, and I'm an advertising law nerd. I'm probably the UK's biggest advertising law nerd. And I've only just found out about this because it was decided in the lowest level of court, in the magistrates' court, and so, or the local circuit court, and their judgments aren't reported. So one national newspaper picked this up, and one barristers' chambers who were involved in the case, but otherwise it's been completely unreported, so nobody knows about it. Basically, what they did was send catalogues out to old people, try and persuade them they could win a share of £10,000 if they placed an order. It would then turn out that actually what they won was 91 pence, not £10,000. They'd been in trouble with the Advertising Standards Authority before, and so this ended up being passed to the legal authorities, and they were prosecuted under Schedule 1 of the Consumer Protection Regulations, and particularly paragraph 31, which is, if you like, a strict liability offence. And they were done for basically creating the false impression that you could win on doing a particular act a prize, when in fact there was no prize, and it was decided that the 91p basically didn't count as a prize. So they were fined £150,000 and ordered to pay the prosecution costs of £11,000. And of course, they'd have had their own costs. We don't know what they are, but I can't imagine they were less than another £11,000. So this must have cost them the thick end of £200,000, but nobody knows about it. Well, you do now. This is more typical. So this is a typical kind of ASA complaint about this investigator Molly May Haig, who's been in the papers recently for some rather silly comments that she made on another topic. She ran a promotion. There were some other similar social media promotions that were run around the same time. And the ASA, as a result, published some guidance, pulling together from all these social media promotions. You've got to select a winner randomly. That was one of the problems with Molly May. She'd had so many people enter, millions of people, that she couldn't work out a way of doing it properly. So she just her team took 100 names out of the hat and then awarded the prize to that random subset of 100 people. But that didn't pass muster. Make sure you can independently check the winners' criteria have been fulfilled. Molly May and the others were offering bonus entries, but there was no evidence that actually, if you did the thing, in her case, you were supposed to share your post on the story, and that would get you a bonus entry. But there was no evidence that that was actually happening, and ensure that all the significant conditions are presented. So that's the sort of distillation of those decisions. I wanted to. There's been this interesting technique that's emerged recently, which is sometimes called winning moments. And I think there's acceptable winning moments and there's dubious winning moments. This is an example, I think, of an acceptable winning moments promotion, where if you enter the code at a particular time, then you could win a prize. And if nobody enters a code during that time slot of, say, 1 minute, then the prize that had been allocated to that 1 minute is rolled over. And so somebody sometime will win that prize. And they said that there were 10,000 winning moments. And they also then had this mop up draw at the end in order to make sure that all of the prizes were awarded. So that is okay. But a couple of promoters have then gone too far. And it's not so much that the promotion is wrong, it's more the advertising for the promotion is the problem. Sorry, I've got to keep an eye on the time here. I'm under strict instructions not to overrun, and my iPhone, the clock disappears. As you can see, the basic point here was that they didn't have this rollover. So if nobody entered the code at the precise moment that the algorithm required, then that prize was lost. So this idea that they had £3 million worth of prizes to be won was nonsense. And less than 1% of the prizes were awarded. And then the similar thing happened with Highland Spring. They did something similar. 10,000 prizes to be won. In fact, a tiny number of prizes were won. I think the COMPAs are onto this, the ASA is onto this. I actually think this is unlawful and breaches the consumer protection regulations. And so if you have somebody trying to persuade you to do this, I would say think very carefully because I'm not sure it's legit. Lots of negative PR, as you can see here, that came about for McCain. BBC News, again, our competition levels being taken for a rise by prize funds. Crypto, we're seeing a lot of this now, and it's a very, very high priority for the ASA. And these their main concerns: lack of risk warnings, the fact that cryptocurrencies are not regulated in the UK. And sometimes you'll get promotions where, like this one, where basically it was free Bitcoin. And you might think, well, what's not to like? But the ASA said, no, it's a serious thing investing in crypto, so we don't want to do it. So just very quickly, a quick word, because I haven't got a slide about charitable promotions. If you want to run a charity link promotion in the UK, there's a legal requirement under the Charities Act. You must have a written agreement between the brand and the charity called a participator agreement. That you must have an agreed solicitation statement. So you say, for every £1 spent, we'll give 50p to charity, whatever it might be. I've also got a concern about some of these win a house promotions where you get people saying, oh, 80% of the net proceeds will go to charity, when if the real number that actually goes to charity is about 12%. And I don't think consumers understand the difference between net proceeds and proceeds in general. So I think, again, those promotions themselves, they comply with the Gambling Act, they comply with the Data Protection Act, but I think it's just the general advertising claims that surround them which are unlawful. That's my 10 minutes. So for fear of upsetting Melissa, I shall stop.
I'm tough.
Thanks, Melissa. Thanks, Brinsley. So hi, everybody from Amsterdam, Netherlands. So first of all, short, something short about sweepstakes and contests in the Netherlands. It's a bit the same as in the UK. The big picture is it's pretty easy to organize sweepstakes or contest in the Netherlands, but there are a couple of thorny issues that you should be aware of. So I fully agree with Brinsley that's maybe seeking and Melissa seeking local advice, local council advice is a good idea. About our law here in Netherlands. So we have a distinction between chance-based games and skill-based contexts, like everywhere. So chance-based games in the Netherlands, it is prohibited to organize a lottery or a chance-based game or a promotional game of or a game of chance without a permit. But the exception is the Dutch Code of Conduct for promotional games of chance. So if you comply with that code of conduct, then it is allowed. We have no registration or filing requirement, no real draw requirement like a notary public present or something like that, or public official like in Italy. We don't have that. There's a set of rules, the Dutch Code of Conduct. It distincts between promotional games of chance with like a 4.5K maximum prize worth. So all the prizes combined, if they are worth less than 4.5K, then the rules are a little bit simpler. If it's above, then it's a little bit complicated. We can, for instance, if it's a big promotional game of chance with a prize worth of more than 4.5K, then there's a maximum total value of prizes of 100,000 euros. For instance, you can only organize one of those big promotional games of chance, and there's a maximum of 20 draws. So then to skill-based contests, we don't have specific rules about that. It is governed by general civil law and a couple of self-regulatory provisions. Same as the chance-based games, no registration or filing requirements, but there are a couple of the self-regulatory requirements. So most notably, the identity of the organizer should be known, number of prizes, value of prizes, eligibility. It should just be clear, to put it short and simple. So recent developments here in the Netherlands, we have a gaming authority. It's called the Kansspelautoriteit. Repeat after me, Melissa. The Kansspelautoriteit. Yeah. So it's drafting new policy rules for the enforcement of promotional games of chance. So that is a breach with the practice that if you comply with our promotional code, then it is allowed. They are planning to replace our code of conduct for promotional games of chance with these policy rules. So that's kind of interesting. And what they are looking into is a prohibition of promotional games of chance for risky products like NFTs, like Bitcoin, and also a prohibition of promotional games of chance for lotteries. And other gambling services. So there has been a delay, and we're expecting these new rules to enter into force somewhere this year. But there's been a lot of delay because of Corona, and because it is a big thing in the Netherlands. Online games of chance were not permitted in the Netherlands until 1 October of last year. Then since then it's permitted, and since then we're getting flooded by advertisements for online games of chance. So our gaming authority is very busy with that, and not so much with promotional games of chance. So a couple of recent developments, recent cases. We had an interesting decision of our Board of Appeal of our Advertising Code Committee. The Advertising Code Committee is our self-regulatory body. It's kind of comparable with the ASA in the UK. So there was this scratch card revealing a lucky number. The lucky number had to be entered into a website to see instantly if you have won. But the participants, when they wanted to enter the code on the website, they had to enter their email address, give permission for receiving marketing communications to see whether they had won. So our Board of Appeal said, okay, that is misleading because the average consumer would not expect that marketing permission requirement. Kind of straightforward. Another case was about Facebook ads with a spinning wheel of fortune, with over it a statement: win 1, 10, or 100 national lottery tickets. The Staatsloterij is our national lottery here in the Netherlands. So there were 9 boxes that showed 1 time, one showed 10 times, and one showed 100 times. And below the wheel it said, give the wheel a spin. Now, the catch was that the prizes were not allocated by actually spinning a wheel. And the odds of winning were much lower than the layout of that wheel of fortune in the ad suggested. So then that was considered misleading, because the average consumer would be misleaded by this wheel of fortune. Well, that's it for me from the Netherlands. One other thing. Had a couple of top tips. My top tip for running a cross-border promotion, I guess, would be start in time. Start in time. If you're gonna do it globally, you're gonna run into a lot of red tape, and you need some time to figure that out. So that will be my top tip. Thanks.
Hello, everyone, and welcome, Bong Bini, as we say in Papiamento here in Curacao. I'm happy to share with you some insights into running a promotional contest in the Dutch Caribbean. So just to give you an idea of which countries we are talking about exactly. So Aruba, Curacao, Bonaire, St. Martin, St. Eustatius, and Saba. Some of you may recall that these 6 islands formerly belonged to the jurisdiction of the Netherlands Antilles. That is not the case anymore, and now we are talking about 4 jurisdictions, being Aruba, Curacao the second, Dutch St. Martin the third, because St. Martin also has a French part that is part of France, but we're talking about Dutch St. Martin, and the 4th jurisdiction that comprises of the islands of Bonaire, St. Eustatius, and Saba, also known as the Caribbean Netherlands or the Best Islands. Now, these countries, of course, are still part of the Dutch Kingdom, but they have their own laws and regulations. Regarding for promotion basics, the legal framework specifically for skill-based promotions. So we would look just like the Netherlands, it's just general civil law that we would look at, and also consider some provisions for consumer protection. For chance-based promotions, including charitable sweepstakes, we look at the lottery ordinance. There's a lottery ordinance for all of the islands, but specifically for Curacao, we speak about an example, the Wega di Number Corso. So that is a numbers lottery. Pick 2, 3, or 4 combinations of numbers. And there is a specific organization that oversees that, and that is Fundación Wega di Number Corso. The lottery of goods is also regulated. And also, surprisingly to note, is bingo and bonkune. So there's a specific law for that, and that describes how the game is being played and what kind of prizes can be awarded. If you will be running an online promotion, in addition, you would also have to observe the provisions of the e-commerce ordinance. And that regards specifically because we will be talking about commercial communication to the consumers. So we would have to observe some specific rules when it comes to that, as to, for instance, the possibility of a simple opt-out, or that the rules must be easily acceptable and clear identification of the advertiser. The regulator in Curacao is the Curacao Gaming Control Board. The other islands, mostly this resorts under the Ministry of Justice. A question that we get frequently asked is that if the official rules need to be translated in the local language. Well, if the rules are in English, English actually is one of the official languages of Curacao and St. Martin, and English is also widely spoken in the other islands. So it is not necessary to translate the official rules if these are in English. And besides, you can also have the official rules in Papiamento, that is the local language of Aruba, Curacao, and Bonaire. And Dutch, of course, seeing that all of these islands are still part of the Dutch Kingdom, and Dutch is an official language in all of these territories. A license is in general not required neither for skill-based promotions nor for chance-based promotions, but there is an exception that you must comply with 3 requirements when running a chance-based promotion in order not to need a license. The first one is that it must be to stimulate the sale or increase the turnover. And the chance-based promotion must be organized or held by and to the benefit of commercial organizations or companies. And the third one is that payment must not be a requirement to enter the promotion. However, you can require that a purchase is necessary, but not directly pay a cash amount in order to enter the promotion. It is not necessary to register a license, and where in some jurisdiction it is necessary to have a notary present, in the Dutch Caribbean countries, it is not a legal requirement, but it is customary for reasons of transparency. The official rules of promotion contests are viewed as general terms and conditions of contract, and that means that they must be made known to the target audience. So, in case of an online promotion, that means that the official rules must be easily accessible and they must be downloadable as well for the consumer. It is possible to own entries. However, if this is subject to copyright, note that the Copyright Act in all of the Dutch Caribbean islands exists for the life of the author and 50 years after the author's death. It is possible to assign the copyright, but that has to be in writing. Regarding charitable sweepstakes, there are some requirements, particularly in Curacao where that is concerned. In that case, it is viewed as a lottery of goods. And being a lottery, it is subject to the lottery ordinance. And that means that a license will be required in all of those situations. The license fee is 10% of the gross revenue, and the requirement for the organizer is that it cannot be a company nor a commercial organization. Charitable sweepstakes in Curacao must be organized by association or a foundation with legal personality. And in addition, that association or foundation must have in its articles of incorporation the objective of organizing charitable sweepstakes. The proceeds must be to realize a charitable objective or for the promotion of culture, sciences, the arts, or general interests. There are also requirements for the prizes. The prizes may not consist of monetary paper nor of money. And of course, all prizes that are advertised must be awarded. And there's a minimum value of 40% of the total gross value of all lottery tickets. The maximum gross revenue is 200,000 guilders, and that is approximately just over 100,000 US dollars. The requirements for the tickets for charitable sweepstakes is that they must have the stamp of the regulator, that is the Curacao Gaming Control Board. They must also have a statement on them that if the prize remains unclaimed for 6 months or more, that the prize will be forfeited to the licensee. And also tickets for charitable sweepstakes may not be sold to minors. If a minor buys a ticket and wins, then the prize will not be awarded. And also, minors may not sell tickets for charitable sweepstakes. A guarantee must be put up, and that is for the payment and delivery of the prizes. So, for instance, the organizer can be required to put up a bank guarantee for the total amount of the prize value. And the guarantee is also necessary for compliance with license requirements, with a minimum of 500 guilders, which is approximately 300 US dollars. There are also requirements for the financial accounting because since you'll be running charitable sweepstakes, of course, there must be insight into a sound financial record keeping. And that must give insight into the ticket sales and expenses, including the prizes that are awarded. And mind you, the financial records must be submitted to the Curacao Gaming Control Board within 2 months of the drawing for review by the Government Accountants Bureau, the SWAB or Stichting Overheidsaccountantsbureau. Bureau. And in case of non-compliance, then the deposit will be lost, and also a possible next request for a license will probably also be denied. So in closing, the tips for organizing charitable, or better said, promotions in the Dutch Caribbean is particularly if it is in English, to use clear and easy language to understand. Use of personal data is subject to the privacy ordinance that is in all of the Dutch Caribbean islands. The GDPR does not apply to the Dutch Caribbean islands except for the Caribbean Netherlands, that are the islands of Bonaire, St. Eustatius, and Saba. So the GDPR does not apply to Aruba, Curacao, or St. Martin, at least not directly. And to observe the general internationally accepted standards, the standards of good practice. Thank you for your attention, and that is all for me.
Thank you very much, Carol, Melissa, Daniel, Risley. It's a pleasure to speak here, like always. My name is Jose Antonio Arochi, and I'm from Mexico. And just so you guys know, in Mexico, we have a law, which is the federal law of games and sweepstakes. Unfortunately, it hasn't been amended since 1947, just so you know. So it's a 3-page law, which is very simple. We have the law, and then the law comes with a regulation, which is like a basis to back up the federal law, which is the regulations to the federal law of games and sweepstakes. And then the internal regulations of the Ministry of Interior have a lot to do because it's the authority that it's regulating this type of activities in Mexican jurisdiction. So can we change to the other slide, please? Basically, in order to carry out a sweepstake in Mexico, we need a prior authorization issued by the Ministry of Interior, like I was mentioning. It's a 10-day 10-day gap to obtain the permit. Right now with COVID, it's taking a little bit less than a month, but it's something very simple. But the issue is, the problem is that it takes a lot right now with COVID on the authority to answer, because obviously this authority has other more important things to do. So it's a little bit complicated with our regulators. But just so you know, the authority behind it is the Ministry of Interior. I had a case maybe like 15-20 days ago of a client that was doing a sweepstake, but it was doing it in American jurisdiction, but they were using Mexican employees. So the consultation was, Jose, does the Mexican regulation can affect us regarding this? And it was no. At the end, if the sweepstake is taking abroad, even though there is Mexican employees, the jurisdiction is in the United States. But this type of consultations, or this type of opinions that we do in a day by day in the firm, it's something that we're getting a lot since COVID started. And obviously the sweepstakes come a lot with all of the regulatory issue, but also it brings a lot, like Carol was mentioning, a little bit of privacy, GDPR issues. Even though Mexico obviously is not part of the GDPR, there can be affections regarding this guidelines in Mexico if there is any type of involvement with somebody that can be having some issues with this regulation. So it comes a lot with giving a very good and accurate consultation for the client, but it involves a lot of privacy issue as well. We had another case which I want to talk to you a little bit, because obviously, like, you know, our sweepstakes day to day is a very small part of our work, but we have a lot of type of issues, and we had a contest or a sweepstake involving sports and teams. When this comes, and there's athletes, and it involves alcoholic beverages, we need a permit from the Mexican FDA authorization, and this will take longer than what I was mentioning. And it was something that my client Danielle sent it to me. So it's important to know, but it's interesting for you to know that it's not just, even though our law is very small and it has just 3 pages, we have to go and see exactly how, in a case by case basis, we have our sweepstakes, or how they are um, um, briefed, or how they are made, so we can see exactly what to answer to the client. And just so you know a little bit, um, other authorities that can be involved in a sweepstake issue, even though the Ministry of Interior is the authority regulating sweepstakes, it can be involved with the Consumer Protection Agency, which is Profeco, the Federal Commission of Economic Competition, which is COFECE, which is like an antitrust authority, and then we can have the Mexican FDA. And you will say, why a Mexican FDA? It's because the Mexican FDA provides regulatory and publicity permits for certain products. So sometimes the sweepstakes involves some products that needs a permit from this authority, and we have to involve the same. So depending on how our sweepstake and how is the consultation made, we need to involve not just the Ministry of Interior, but other authorities. And regarding social media and influencers, in Mexico, unfortunately, we don't have anything. We have been behind the Senate to try to obtain maybe not a law, but yes, guidelines, so we can see exactly how social media and influencers can be regulated in a way. Everything is limited to a contract, and we have to be very careful on how we draft the contract, because sometimes we have influencers that obviously are underage, so we have to be very conscious on labor laws. We also have to include privacy issues. So just so you know a little bit, social media influencers, unfortunately, we don't have anything. The private practice is trying to educate the authorities, so we can try to get guidelines, so we can see exactly what we can do when there's an issue with this important platform. And just so you know, there was a new law that came into effect at the end of last year, which is the transparency publicity law. It's a larger name, but just so I can make a summary of it. But it involves media hubs, agencies, and advertisers, and it affects the relationship between the 3 of them, and it involves influencers in social media, because the law is so general that an influencer can be considered a media hub, and for this reason there can be penalties. So this has nothing to do in a way with influencers, but the influencers at the end, because they are part of a transaction sometimes with advertisers and with agencies, they can be considered a media hub. And I wanted to bring this to context. Regarding social media and influencers as well, like I was telling you, there's other authorities that come into scene, such as the Consumer Protection Agencies, Mexican PTO, the Mexican FDA, and like I was telling you, COFECE. So Consumer Protection Agency, the Mexican PTO for unlawful competition issues, the Mexican FDA for certain publicity regarding certain products, and COFECE for certain antitrust issues. So sometimes that's how we have to be having a little bit of imagination and going through different venues regarding the case. So it's a lot on a case by case basis. And hot topics, obviously, we're trying to get a type of regulation regarding social media influencers, and they're saying that there's going to be an NFTs regulation in the short run. Now that it's very trendy and it's very posh in these times of years. So thank you very much, and hope if you have any questions, please let us know. Thank you very much, Melissa.
Thank you. And getting back to the US and just to talk a little bit about us and developments here. As you know, the US basic framework, of course, we look at the lottery laws and then we look at the sweepstakes specific laws that are more consumer protection oriented, and talk more about disclosures, and false, and making sure that there are no unfair and deceptive acts and practices when it comes to making misleading claims about a sweepstakes. So first we look at whether there's an illegal lottery, whether prize, chance, and consideration are all present. And in particular, the focus, of course, tends to be on consideration. You know, we tend to look a lot at now whether examples like, you know, can you require download of a paid app? You know, is something electronic going to be consideration? And so I just put here, there's going to be a lot more information on the slides in this section than I'm going to talk about for time purposes, but in particular, one of the things that's interesting is those states where there's actual express precedent on the fact that non-monetary consideration can be illegal, where there's, you know, something more generally than just visiting a location or a store or something like that. So that tends to be where a lot of the focus nowadays, whether it's attorney general opinions or just analysis, tends to be, and there's a lot of gray areas when it comes to things like electronic activity or long surveys or giving pictures or giving the IP rights to pictures in particular. Next slide. I'm doing the next slide. So with the more consumer protection oriented laws, of course, we tend to focus on what's in the rules, and what do we need to do? What disclaimers do we need to have? There have been some interesting new cases in the past year or two on the issue of what needs to be in the rules, and in particular, do the rules need to be disclosed? And do the new rules need to be accepted expressly by entrants? And so in particular, there have been a couple of class actions on this. One case, Root versus Robinson, was filed in the Eastern District of North Carolina, where it was alleged that because entrance into a sweepstakes had not accepted the rules, and rather because the rules had not been disclosed actually until they were disclosed to the winner along with the affidavit of eligibility and release, that they were not binding, and that the sweepstakes itself was unfair and deceptive. And so, you know, this is something that I think sometimes you get a sweepstakes where there's either not clear and conspicuous disclosure, or somebody messes up and the full rules aren't posted. And this is one of those cases where you do actually get a class action that is pursuing this issue. So it'll be interesting. This was just filed last June. It'll be interesting to see how this comes out eventually. Of course, most class actions settle, but you know, we tend to counsel our clients, look, you need to get these rules posted early and clearly and conspicuously. And you know, this is kind of the case that shows, you know, this is why we counsel that. It's hard to bind your entrance to something that they just don't see. All right. Here's another case on specifically addressing skill and user-generated content contests, where there was a similar situation in that there was an infirmity in the rules uh, and also in acceptance of the rules. So with skill contests, of course, it's very important to create rules that clearly disclose here are the rules for entry, here's what we expect out of the entries, here are how the winners will be selected, the judging criteria, here's who will be judging, and then here are sort of the criteria for what is going to be a compliant entry. In this particular contest, basically it was a best chef contest, and anyone could create a profile on a website and then ask people to vote for them, and then whoever obtained the most votes would proceed round by round until there was a winner of the favorite chef who would win a whole lot of money and an ad in Bon Appetit. It was a public voting contest, and people could buy extra votes after getting a free vote. And so the allegations in the lawsuit are that the terms and conditions and the privacy policy were not available, were not clearly and conspicuously available. And then there were also allegations about failures to disclose the value of the prize, misrepresentations about the terms of participation. Also, and this is sort of basic skills contests law, that it wasn't even a skills contest at all because people weren't being voted judged on their cooking skills, and it was just a popularity contest. So as we talked about, you need to have the rules disclosed in order for, to avoid essentially basic unfair and deceptive trade practices and sweepstakes issues. But with skills contest, in order for there to be a skills contest, case law in the US says that you do need to be judging and or selecting the winner according to some sort of skill. You can have sort of athletic competitions in some cases or the like, or you can have a judge contest where you have expert judges who are selecting the winners according to some stated criteria that are based on some sort of skill, whether it's best chef or best photo or something like that, and they need to be generally clearly stated, and the judges have to have the expertise to select the winner based on the stated skill. So here's a case in which that is being challenged. Again, it's a class action, but it is a class action that's based on, clear precedent. This is something where generally when we have skill contests where there is a voting component, which is not uncommon nowadays, generally I recommend that you do then also have a judged component with judges where there are experts. That also adds a sort of element of control over the winner selection to the sponsor, in that, to the extent that you have judges who you've selected, you have some ability to, the public can be a little bit of a black box, but with judges, they tend to be a little bit, it's a smaller group. It's tends to be a little more rational, shall we say. I don't want to say the public is irrational, but you get my drift. So in terms of general guidance on skill contests, or in particular UGC promotions, user-generated content, there's that guidance on judging and voting, where you need that judging expertise, or ideally independent judges. You need clear winner selection guidelines. You also want to watch out for voter fraud. and that issue of is a voting contest even a skill contest, which was really the basis of the challenge in that case. You also want to watch out for the FTC endorsements and testimonials guidelines, which in the US say that to the extent that you are incentivizing entrants who are submitting, say, a recipe, asking them to post online, or a photo with a sweepstakes entry, that you need to ask them to disclose that they are posting their content online with the purpose of entering a sweepstakes. So disclosing with hashtag sweepstakes entry or something like that. And then be mindful of the intellectual property considerations, whether it's you're asking for the rights to their recipes or that they may be including third-party content in their entries. So that's something to consider. Also, while in skill contests, you may be able to include some sort of consideration requirement in most states, because there's no chance, and that there may be a lottery. The lottery issue is such that the elimination of the of chance may allow for the inclusion of some consideration. That's not the case when it comes to purchase in some states. I want to be mindful of the time, so I'm skipping quickly through. Charitable sweepstakes and raffles in the U.S. Raffles are very strictly regulated under state law, and they're different in every state. Raffles are where you have prize, consideration, and chance all present. Generally, only a nonprofit is going to be able to run it. And there can be restrictions even beyond that, where the nonprofit has to be located in the state for a certain amount of time. There may be registration and licensing requirement. You may not be able to advertise online. There may be limits on prizing, so it's important to understand the laws there. Increasingly, we're seeing charitable sweepstakes being run where there's no kind of consideration or purchase requirement. That's an interesting structure, but it's important to look at, particularly if you're a for-profit that's getting involved in those charitable sweepstakes. There have been several cases in California in particular brought against companies that were for-profit but did not register under the promotional fundraising laws or the professional fundraising laws. And California pursued cases against them for that, and also for failing to disclose a free alternative method of entry, thus, complying with the idea of the promotional sweepstakes rather than the raffle. So it's those involve Prizeo and Charity Buzz and Omaze, and you'd want to look those up if you're thinking about that structure. The other thing that's been popular in the last year or so in the US is, of course, the idea of the vaccination sweepstakes. There was $1 million given away in Ohio, but and there's one right now in New York, but they're popular for employers as well. And you need to look at whether requiring somebody get a sweepstakes or a vaccination in order to enter is consideration. Generally, for private entities, there's some sort of free alternative method of entry being offered for just that reason. There's also some privacy issues there. The employer is not necessarily going to be bound by HIPAA, but it's something to look at depending on the employer. It also, you need to look at whether that may be viewed as coercive by the employer, and whether you can allow it on employment time. So there's some important labor law issues there. So the other things that have come up are things like, gee, if you had to change your sweepstakes laws or your sweepstakes rules because of, say the event that you were giving tickets to was postponed because of the pandemic, was that covered by your modification clause? Was it covered by a force majeure clause? So these types of things came up during the pandemic. There were also a whole bunch of COVID fraud type cases brought by the FTC. So you certainly didn't want to be caught up in that wave of cases. The other issue that's been interesting this year is sweepstakes either giving away an NFT or cryptocurrency, or in fact, one company that is a crypto exchange has been sued in a class action suit that's ongoing, where the plaintiffs alleged that the crypto exchange led them to believe that to be eligible, they had to purchase cryptocurrency or sell cryptocurrency in order to participate. So there was just a denial of a motion to compel arbitration, and a grant in part and denial in part of a motion to dismiss in that case just last week. Basically, there's an allegation that there was a failure to clearly and conspicuously disclose a free alternative method of entry there. And the court said, well, there's not an illegal lottery, but it's a question of fact as to whether there was an unfair and deceptive failure to disclose the free AMOE there. So that'll go on from here. Certainly that, there are interesting issues there about what kind of disclosures are required when you've got an NFT giveaway or a crypto giveaway. Is there consideration if you have to, say, pay the platform fees or get a wallet in order to receive an NFT or purchase crypto or receive crypto as a prize, and all kinds of intellectual property issues there. So definitely important to proceed with care when participating or offering a crypto sweepstakes. So I think I'm about out of time. There are several other new cases, but these are some of them. And I'll open up to any questions that we may have or any last minute comments. All right, if we've received any, then or anybody submits any, then we will answer them in writing. And I believe that this deck will be distributed to all entrants. So thanks so much for attending today.
Marissa, sorry to interrupt you. I think there is a question regarding if there has been like a multi continent or multi jurisdiction. I understand, that's what I understand from the question. If there is like a multi jurisdiction sweepstake, if we have been involved in a multi country, that's what I understand. And if you want, I can answer that. I've done it with many jurisdictions in Latin America, and it's hard work because you have to do compliance regarding each of the jurisdictions, but it's possible. I think the most important roadblock is that obviously it changes from jurisdiction to jurisdiction, but what we've done is doing like an Excel sheet and seeing exactly what are the yeses and the nos in each of the jurisdiction, and then we go back with the client and give them like an opinion. But that's just what I wanted to answer. Sorry to interrupt.
Yes, indeed, I can answer that as well. I worked with Jose Antonio as well on multi-jurisdictional sweepstakes, and what I did see was that, for instance, there were different consent forms depending on the country's requirements, especially for storage of personal data.
Yep. Data and translation tends to be the hardest things. A lot of the time you can put in different clauses to make one set of rules, but there tend to be one or two jurisdictions that maybe require a separate drawing or something like that that are particularly tricky.
Can I don't know whether I can be heard now. Yes. Yeah, I mean, Melissa did touch on this at the beginning. I guess the other way would be to try and use one country's laws and make sure you're compliant with that country's laws. And I mean, it's not foolproof. There are risks, but you could possibly meet those by not allowing entries from countries where you just think we simply can't comply. I mean, one example was given to me. I believe it's still the case in Italy that if you run a promotion in Italy, you're supposed to have a winner from Italy. So in the scenario that you're describing, one way forward would be to make sure you don't do anything to create a kind of link with Italy. So, for example, don't make the prize a trip to Rome, and or don't in some other way create a link with Italy. So just try and keep it as vanilla as possible. And if you're a company that doesn't have any kind of presence in Italy, it doesn't have any assets in Italy, then even though you may technically be breaching Italian law, there's probably very little the regulators can do about it. What are they going to, who are they going to enforce against? So, and then I think if you would say if you decided to try and use as a benchmark compliance with the data privacy requirements of one of say Californian law or of GDPR, if you're compliant with those kind of high watermark laws, chances are you're going to be compliant in most places. And if you've doubled up on that by saying that the laws of the UK or California govern the promotion, then that's hopefully going to be a practical way forward. But as I said in the answer to the question, if you're going to try and register in every country, I mean, as I understand it, I think it's still the case in Spain and Italy that you're supposed to register 90 days in advance. I think it's 90 in some places, even if it's 30. Most clients come to us and we say, well, do you have enough time to complete the registration requirements? And I think even if it's 30 days, they'll say, well, no, we're going live next week. So that's often the problem. That goes back to the point that Daniel made right at the beginning as well of leave yourself enough time. And the more countries you're going to run your promotion in, the more time you need to leave yourself.
I think that's why it's, excuse me, a fraud. Always good to know, okay, this is where we have offices, this is where we have servers, this is where we have stores. So these are the countries that are good. And again, the prizes, what prizes may take people into different countries. So you know which countries are likely to consider you to have almost the minimum contacts, if you will. And that will go into your risk analysis as well, because some countries won't take as great an interest in your promotion if you are sheerly advertising online with no other ads sort of reaching in, if you will. And that can go into the pot that is your risk analysis as well. Right, Jose, are we missing anything since I don't have as good a view into the Q&A?
No, sorry. No. I think that was the only question, and I think it was good that all of us got involved.
Excellent. Well, thank you everybody for attending.
Thank you, Melissa, for putting this together, and Gala, Stacy, all of you guys. Thank you very much.